I want to introduce to you Rick Russell and Heather Swartz. Rick has been working full-time in dispute resolution field for over 25 years, having practiced in civil litigation as a lawyer, a university ombudsman, a mediator, an arbitrator, fact finder, and trainer. And today's Blue Plate special is? Trainer, okay. In 1993, he co-founded full-service conflict management firm Agree Dispute Resolution. Heather, a partner at Agree, is in her conflict management practice. She provides mediation training, and again, this whole raft of all the kind of stuff. She didn't want me to read that long, exhaustive list. Trust me, she's done it all and has experience in it all, and is going to be a great resource. She's a co-instructor with Rick in Dispute Resolution Level 1 and 2 in Organizational Conflict Approaches and courses in the Certificate Program Conflict Management, Institute of Peace and Conflict Studies, Conrad Grebel University, University of Waterloo, where my uncle used to be the dean and the provost. Bert L.L.B. is my uncle. There you go. So, you know, we're connected. We're probably related, right? Anyway, I want to thank them for being here. I want to thank all of you for being here, and I hope you all enjoy this session on ethics. Thank you, Rick and Heather.
Thank you so much, Scott. Welcome, everyone. And I'm glad that the lunch was fairly light. Fish should mean that we can keep our eyes open for the afternoon session. And what we hope to do is to give you an interactive type of experience. It's going to be a little bit like time-lapse photography. So once we get past a couple of slides that hopefully will set the ground for everyone in terms of that'll work. So what we're hoping to do is to allow us to all have common language around workplace assessments, fact-finding, and investigation. We'll do a couple of PowerPoint slides that give us that grounding. Then we're going to do the time-lapse photography scenario, where you'll be presented with a situation. We'll have some discussion around what are some of the ethical considerations that go into the next steps as you engage in an intervention with this particular organization. So reminding us or letting us know about workplace assessments, sometimes you'll find that they're called a workplace review, depending upon the organization, or perhaps a health check. One of the organizations I'm working with currently is calling it a check-in. But it's really an opportunity to take the temperature of a workplace, and the overall objective being, in the end result, after the assessment review or check-in is done, to create a healthier and more respectful workplace environment for everyone who's involved in it. It provides a means of assessing the perceptions, the perspectives that all of the employees have in a workplace. It's really, in many instances, speaking to the individuals who work there, hearing their voices, hearing the way in which they talk about their experience, their narrative of their workplace environment, in order to look for the common themes. So you might be within the health check looking at a unit, you might be looking at a particular department or the whole organization. It's forward-looking. It's intended to be along the spectrum of interventions, a preventative type of forward, future-focused, all-encompassing process, not a specific investigation or fact-finding into a complaint. So it's not. What we hope to do when we do workplace assessments is not only look at what the issues are in a particular environment, but also to identify what's working well within that environment in order to exist. So one of the questions that we will ask in either a survey format or an interview, what's working well from your perspective? We need to hear that in order to not throw out everything that's happening within the organization. What are employees seeing as positive? In addition to some of the positive elements, we're also looking for issues of concern that individuals are identifying within their workplace. The forum, and I mentioned that we might gather information using a number of different techniques. The forum may be, and my preference is face-to-face interviews, not always a cost choice for every organization, but certainly the opportunity to dialogue with individuals allows you to really hear their perspective. Other alternatives may be focus groups, so a select number of individuals. In some large organizations, we find that a focus group may be the thing that makes some sense. Really important considerations are who, if you're not interviewing all of the people within the organization, who is randomly selected? Are there people whose views need to be taken into consideration because they may be reflective of a certain sector of the population? So how do you get that representative perspective of the unit or department? And the other alternative, of course, is some sort of survey format with lots of opportunities for people to be open in terms of what they want to share with you. And what you're looking for in a workplace assessment, you're not searching for the facts. You're not going to be identifying who said what, but rather you're trying to identify what are the common themes. What themes are emerging from the information that people are sharing with you. Often you'll be asking, if you have the opportunity to have a face-to-face interview, when someone says, you know, my workplace is toxic or it's poisonous, you're asking more questions to probe really what's at the root of that. What's driving the conflict? And sometimes when we're analyzing the conflict, we'll actually use the tool that you may be familiar with, the circle of conflict. And at ADRIC, we've also created what we call the Agree Healthy Workplace model. It's a tool that we use to analyze the experiences that people are telling us about and then try to figure out some recommendations. So we're looking at a deeper level as to what are the issues. The result of the workplace assessment, in addition to the employer demonstrating to their employees that they're truly interested in how people are experiencing their work life, one of the things that we do is in a report format suggest some recommendations. And those recommendations, often we're relying upon the voices of the individuals who are living the work experience. So I'm often looking at reflecting back what they've said might work better within their workplace, what they feel is important. At the same time, as conflict management professionals, what we're hoping to do is to diagnose and analyze what's happening within the workplace in order to think about the different types of recommendations that might improve the work experience. In some instances, it may be some structural recommendations, things that the organization needs to do themselves in order to improve what's happening in the workplace. Maybe it's communication mechanisms, maybe it's the way in which they've structured decision-making and the authority. Is it contingent with the responsibility? Are there other things that they need to take into consideration? In some instances, we may be recommending what I would call restorative types of interventions, and that can go the full range from, let's say, group training, individual coaching, mediation, a team building, a exercise, setting a code of conduct for the workplace. So dependent upon what individuals have identified as the concerns within their workplace, we may make different recommendations. What I find is a workplace assessment in that particular tool, in terms of the ADR spectrum, it's more effective when what you would say is there's a broader, higher level of dissatisfaction across the workplace, or a series of wider concerns that involve a number of employees. So that's a brief, really quick introduction to workplace assessment. And I'm going to hand it over to Rick to talk more about the fact-finding and investigation processes before we get into our scenario.
Great, thank you. Okay, can you guys hear me okay with this? Okay. So I want to get some sense, how many of you folks here once in a while do what we've just described as a workplace assessment as part of your practice? Okay, for a good number of you, that's true. How many of you do what you would call fact-finding or investigation as part of your practice? Okay, a smaller number, but still a significant number. Okay, so what we thought we'd do is we'd talk a little bit about fact-finding and investigation to make the distinction between the two, because many times clients don't make the distinction between the two. So we want you to understand the distinction between the two and what's important about the distinctions between the two. And the exercise is really designed to help you experience what it's like as you look at these different processes that we use and draw your own conclusions about some of the challenges that these things represent when you're actually trying to put them into practice in real world kind of situations. So speaking about fact-finding investigation, these are where you're called in really to look into whether something's happened in the past. Okay? And you're really doing fact-finding as opposed to gathering people's perceptions. So people, you appreciate the difference. Fact-finding means we're looking backwards, we're trying to find out through various forms of evidence, viva voce or face-to-face interviews, data collection like documents, emails, for example, those kinds of sources of information, trying to figure out just what happened. And then you're going to measure what you find happened on a balance of probabilities against some objective standard of behavior that's typically assigned either by law or by the workplace authority that retains you. So their policy, their sexual harassment discrimination policy, or their human rights policy, and sometimes it's the law like the Occupational Health and Safety Act. But you can see that quite a difference because you're looking backwards and not forwards. You're gathering and you're determining these things based on evidence and not what a lawyer would call hearsay, right? And you're trying to apply a standard to the evidence. And so this just gives you an example. Whoops, it doesn't because I didn't put it on. This shows you some of the things that we can be investigating. And I think, based on some of the notorious cases we've all seen come up, I think some of these things you'll be familiar with these kind of things, right? Some of the ones that aren't necessarily as well known, policy breaches, sometimes the breaches are codes of conduct for executives, for example, which aren't necessarily harassment or they aren't necessarily discrimination, but they can be a higher standard of conduct expected of executives that they have to achieve based on codes of conduct within their own organizations. And sometimes the investigations even pertain to something like a malfeasance, like whether something was stolen or that kind of stuff. So it isn't always about what we call human rights related things or workplace harassment. Sometimes it involves other things, okay? So I'm going to talk a little bit about fact-finding, and I'm going to distinguish fact-finding from investigation. Because in the literature and in the work, typically they are two distinct features, although they involve a lot of the same things. So a fact-finding typically is to find out whether there's enough evidence that would support the use of resources to do a full investigation. So some of you in the room might be lawyers. So the kind of thing you're doing with a fact-finding is you're looking at whether or not there's what a lawyer would call a prima facie case. And a prima facie case, to sort of translate the Latin roughly, is to say a case to meet. Is there enough information that if you believed it would give rise to a substantial complaint that breaches a policy? So on a fact-finding, you're not really weighing whether you believe what people are saying. You're just gathering enough information to say, if what the complaint says happened, would it constitute a breach of any number of policies you're looking at, okay? So fact-finding would be the first step, and then if you determine that there was enough evidence to establish a prima facie case, a case on its face, then the organization might choose to pursue a full investigation. What in this room earlier, when we were looking at investigations, what they call a formal investigation, okay? I think that pretty much covers that. So then investigations are like the full Monty kind of thing, the full thing, where everything gets exposed and you look at everything, right? Those of you who like those kind of analogies. It's rights-based. So notice how a workplace assessment isn't really about what people are entitled to. It isn't really backward looking to say, has somebody's entitlement be breached? Whereas an investigation is a rights-based process. So it'll have some of the characteristics and features that you'd see in other rights-based processes, like you'd see in arbitration, or some of the features you might see in litigation. Because it being a rights-based process, the job is to determine what happened on a balance of probabilities and make a determination whether somebody was right or wrong in doing that. And the balance around whether they were right or wrong is, did they breach a policy or a procedure that they had an obligation to meet? People follow all that stuff? So can you see how, because you're doing two different things with two different purposes, the design of the process will be fundamentally different because it's trying to accomplish a different objective. So this is really what you're doing. It's an informative process. The investigator's interviewing the parties and the witnesses. It's not always that you interview every witness that everybody points you to, because you have to decide whether or not that witness would have probative evidence. Sometimes people want you to interview everybody who's ever met them, including their second grade teacher, because they'll tell you what a great person they are, right? So you make a determination around what evidence you actually seek out. And also then you'll look at documentary evidence, electronic evidence. And again, the standard, the evidentiary standard, is a balance of probabilities. So the question you're asking yourself is it more likely than not that this happened, right? So it's sort of 51%. And just as in a civil standard, as in a civil court, if it's not established on a balance of probabilities, if it's 49% and not 51%, or even if it's 50%, that means that the complaint isn't proven. The onus is on the complainant to adduce evidence that will, right, that will establish the complaint. And then this is basically, the notion is whether or not it's a breach. And as we've talked about in other things, it's not enough to say, I found that this happened and I found that that happened and this is the standard. And because I found this happened, there's a breach. What you have to do is you have to take the reader of the report from the findings of fact through the policy and establish why do those facts constitute a breach of this policy. So what's your analysis? So the report would be very much, those of you who are lawyers or people who've read court decisions, the reasons for judgment would be the same as a report that an investigator would do, taking you from the evidence through to the policy and the law and applying the policy or the law to the evidence. And stop there. Any questions about that stuff? You notice how Heather got to do the really interesting, sexy stuff and I get to do the boring stuff? There's a pattern, actually. Anyway, so if you have a look at this, the reason I like this is it gives you an idea of where each of these processes fit within the continuum. So as you look at the top of the dispute resolution continuum, you see the processes where the parties have the most control, where typically they're less costly, and typically they're quicker to undertake. So conflict coaching, for example, which workplace assessments often give rise to recommendations around conflict coaching if, for example, a manager's not good at managing conflict or an employee's not good at managing conflict. Negotiation among the parties. Mediation, interest-based mediation where an impartial third party tries to assist in resolving the dispute. Then in the middle there, you get a number of procedures that are informative. So the idea here is the third party isn't just facilitating, but the third party is actually providing some third party input, value input into whether or not there's been a breach. So early neutral evaluation, some of you may have done that in a civil litigation context, where a party can actually ask whether or not they can check with an expert to say, is this an example of something under the Insurance Act? You can do an early neutral evaluation. So it's like an evaluative mediation, but it's not a mediation, it's just to get the expert's opinion, and usually for the purpose of trying to be persuasive. Then finally, non-binding arbitration. And many arbitrators would say, well, if it's not non-binding, it's not arbitration. But there are people who go through a hearing format to get a decision that's non-binding, again, usually for the purpose of having that as a persuasive device to try to resolve the dispute, right? And then finally on that continuum, you find the fact-finding and the investigation. Because the investigator makes a non-binding recommendation at the end of their process and basically says, based on all the evidence that we've looked at and based on the application of the policy or the law to that evidence, we conclude there was or was not a breach. So it's not all the way down here with like arbitration and litigation. It's not adjudicative in as much as it's not determinative. The company can read Rick Russell's report and say, that's all really well and good. We just don't agree with you, Rick. Those might be your findings, but we don't think that's harassment. You think it's harassment, but we don't, right? So it's advisory, and that's what puts it there. If we were going to put a workplace assessment, I would say a workplace assessment is sort of between mediation and early neutral evaluation. The reason I'd put it there is a workplace assessment, you're gathering information in a facilitative way, and then you're providing that information to the employer, but you're not providing it in what I would call a raw form. Like, you're not just giving them the notes of the interviews. You're not just giving them the results of the survey. You're taking that information, you're digesting it, you're analyzing it, and you're giving the employer an idea of what does this mean? What does the data that we've gathered mean? And then providing an analysis saying, okay, what do we say the drivers of conflict are? What are the behaviors we'd expect to see? If we're seeing these behaviors, what does that tell us about the workplace and whether it's toxic or what's going on? And then a set of recommendations around, okay, if we're correct in what we've found out, and if we're correct in our causal analysis, here's some things that ought to help, and here's why we think they should help. So you see how it's kind of in the middle there. It's not purely facilitative, and it's certainly not adjudicative in that it's just advice to management. And then, of course, as you go down, you get arbitration, which is like a private judge, of course, and litigation. And then down at the bottom, we've got our favorites, which are power-based approaches. Things like civil disobedience, boycotts, strikes, lockouts. Oh, and one of my favorites that doesn't happen to be up there, voting, which is a power-based process, by the way. And then violence. So you can sort of, I think it's important to be able to contextualize these things. Any questions about that stuff? Yeah.
Just to get clarity on the difference between your non-binding arbitration and your fact-finding investigation.
Yes. Good. Okay, that's a great question. The main difference would be this. In an arbitration, typically the process you follow is most often a hearing of some kind. It's like you'd see in a court drama. It may be an expedited hearing. There may be a relaxed rules of evidence. But typically what's happened is one side presents their case, another side presents the case. Each party either has a representative or someone who speaks for them, and they advocate around what the law is and what the legal conclusion should be. And then the third party makes a determination by applying those arguments to the facts. Whereas an investigation more comes out of the inquisitorial system, right? And you know, in common law, we have the adversarial system, but that's not the most common system in the world. The inquisitorial system is used vastly more than the common law. And that's really what investigatory approach comes from. It comes from the inquisitorial system from continental law, okay? For those of you who are interested in that kind of stuff. Great question, though. Okay, so I'm going to just talk a little bit about the scenario, and then we're going to just throw you into it, okay? And we call this a time-lapse scenario because what we're going to do is we're going to give you some information, and we're going to ask you some questions, and what we want you to do is scratch your head and think about it, and then decide, okay, what do I think I'd do? And why do I think I'd do that? Okay? That's fun, right? Isn't that usually kind of fun? That's the main reason we do it. The secondary reason is people often learn better from this stuff, right? And the reason why I call it a time lapse is any of you who used to watch time-lapse photography on TV when I was a kid? My dad used to make me watch this stuff. He's a photographer. And you'd see the blooms bursting, right, over time. Well, it's the scenario's like that in that you've got some information at time X, and then we have a conversation. And then I give you some information of time X plus 1. Then we have another conversation, and then time X plus 2. So what you're getting to see is, so if it went this way, then what would you do, right? So you get the notion of the whole thing? Okay. And I call it choose your own adventure because you can kind of say, what would I do in this situation? And then based on how it unfolds, you can say, oh, if I'd have done that, this is how it unfolds. And you could say, if I'd have done some other thing, I avoided this unfolding, right? So, but you actually get to kind of see how the story evolves. So, Heather, do you want to help me distribute the first episode?
You may need a pen if we don't have one handy, because you might have to write down some of this. You don't have to hand in your results. Dogs are out there.
So here's the plan. We didn't know how many people would come, so it's always hard to prepare when you don't know how many people would come. What I want you to do first is just read it, spend a bit of time on your own thinking about it, and thinking about what you think you'd do. Once you've done that, we're going to give you about, 4 or 5 minutes to do that. And then we're going to set you free to turn around in your chair or talk to the person next to you and talk about it for about 4 or 5 minutes. And then we're going to pull you all together and we're going to talk about it a bit together. Does that sound okay? Cool. Away you go. Okay, I just realized, because we're on a webcast, I'm actually going to read this. I don't mean to insult you guys. I know you can all read, but it's not going to be much fun on the webcast if they can't read it, because then they can't really participate. So here's the first scene. You're engaged to conduct a workplace assessment for a 10-person unit of a medium-sized company, who we call the employer from now on, that you frequently do work for. Your contract with the employer sets out your responsibility to conduct individual interviews with each of 10 employees, 1 supervisor, and 1 manager. You have agreed that you will aggregate the information and you will not be identifying individual sources of information, and you have communicated this to employees through the employer's announcement regarding the process. So you've drafted a letter or a memo that the employer sent out, okay? During the course of your interviews, you learn of several instances where it appears that 2 different employees allege that they've been discriminated against, perhaps on repeated occasions, on the basis of a disability. In one instance by the supervisor, and in the other by a work colleague. There is a connection between the 2 and at least 1 common witness. Based on your interviews, you believe that in both instances, the discriminatory actions are innocent ones and you recommend mediation. And then there are 2 questions to consider. Are you permitted to identify the parties to the employer? Second question, if not, what are the appropriate next steps? Yeah.
Why was I brought in on this?
So, well, why were you brought in on this?
What's my scope of work?
Oh, you were brought in because they knew that there were some difficulties. There have been some noises made about a supervisor and some noises made about some employees that they don't really know what the right next step is, and they figure they can take the temperature and then they might know better. Yeah.
What province is this in?
Oh, let's just say it's in Ontario, because otherwise I'm likely to screw up and tell you something that's not true. Okay?
No identification to the employer at this point.
Oh, no, I just want you guys to talk a bit for now. I'm sorry, I just read that for the audience at home. Okay, folks, let's get together and we're going to talk about it in a shared way, if we can. I know you didn't get to the bottom of it. We never give you time to get to the bottom of it. But let's talk together. Let's talk together. So the one question is, what are your views about, are you permitted to identify the parties to the employer? What are your thoughts about that? I know this gentleman had some thoughts because he offered some earlier. The short answer is no, and then the reason why not?
Because you told them that you were not going to do that, so you need to speak to them about that.
Right.
No, you have to have permission to do it.
Okay, so no, because you got a condition around how you use the information, and you're asking to use it in a way that they haven't given you permission. Great. Yep.
But then assuming you get their consent, by not, it's to their advantage, because by not agreeing to release their names, then it's very difficult to move forward with any allegation.
Okay. So one of the things you'd do is you'd have a conversation with those particular people and ask whether they felt comfortable doing that. Yes? That's other people sort of feel that might be a one way to go forward? Yeah?
I certainly agree with that approach that you've got to obtain permission. At least
Yeah.
that's the way I read it.
Right.
Before you can identify individuals.
Right.
Because they have to be identified in order to participate in mediation. Everyone else in the workplace is going to know what's going on.
Yep.
Unless you took it outside, I guess. But I think the piece that's really missing is some sort of education on what discrimination is, so that all of the people involved in the organization are aware. And then you can look at whatever process is involved with regard to, when the employer has to have that policy in place.
Right.
Once they're educated, and then you can look at whether mediation is a proper route or dismissal.
Right. So I want to posit something, though. Let's assume that you talk to them, but they say no. Because the easy thing is if they talk to them and say yes, right? That's easy. But let's say you talk to them, but they say no. What are your obligations, if any, toward the employer or to the other employees? Yep.
I question whether you even go to the step of asking them to release their information, things like that.
Okay. Tell me about that.
I think you're going beyond your mandate. The employer wants to know, A, do I have a problem, and B, what do I do about it?
Mm-hmm.
So I thought that maybe when you go back to your employer and say, yeah, I found this, and I found out that you got a problem.
Right.
In fact, one of your supervisors is part of the problem. And recommend that you undertake a policy of problem solving amongst your employees, a little
Okay.
education, as a colleague here just pointed out, and then offer mediation as a way to resolve the dispute. So
Okay.
back to the employer, I found out what you want to know, yeah, you
Yeah.
got a problem. And but then the next step of people identifying themselves coming forward, that has to be based on creating an environment in which they're likely to do that.
All right. So what you're pointing out is we could still do our mandate without taking that step, and you could probably get a satisfactory answer for the employer. Is there a risk, though, that the employer might say, so you knew this was going on, and during the course of this whole month, you didn't let us know? Like I totally agree with you that you're within your mandate. I guess this is where it becomes maybe a bit ethical, and two, sort of what's the best practice, right? Yeah, because I think you're right. It's a judgment call, right? Any other comments before we? Yep, over here.
There's also the implication on the other participants in the employees, because they have been told that this is going to be an environment where they can speak freely.
Yes.
And that it's never going to go to management. But then if you then turn around and say, except these three people who said we can go to management with this.
Right.
I think there's a certain betrayal of the process when you do that, and that can poison any protocol you put in place after the fact to address it.
Mhm.
So, I agree with the fellow over there. I think you stay within your mandate, and then you look at, rather than going straight to a sort of mediating an issue between people that's described as being innocent
Mm-hmm.
errors of judgment, you can look at a workplace training process that brings together these issues, but also camouflages them with other issues.
Right.
Such
Right.
as how you treat people with disabilities, how you treat people with gender, how you generally treat
Yep.
people with
So an educational program like
an
that.
educational program
Okay.
rather than going to a mediation approach, because
Okay.
I think the general culture here is one where this has been able to be, has occurred and has been permissible. So in a lot of ways, you want to try and influence all of the other people in the unit.
Right, okay. So there are a lot of complex considerations going into what you might recommend. I want to take you guys to one other little thing first, though, if I could. And that is, so let's assume something. Let's assume that the note that went out said exactly what we said, is that everything is going to be aggregated and nobody's going to be identified. However, in your retainer agreement with the other client, the employer, right, the retainer agreement includes a clause that says, and if something is brought to light that constitutes a breach of law, that the confidentiality is waived in that circumstance. And as you think about it, what does that say then? Yep.
I think it's very important before you start the whole process,
Yep.
that you insist that you have a meeting with the management to explain to them your approach
Yep.
and how you maintain the trust.
Right.
And you also have a meeting to introduce yourself and approach and the limitations of the process
Right.
to all the employees before
Right.
you start the individual interviews.
Sure.
So nothing is a surprise.
Right.
You explain to them up front
Mm-hmm.
the limitation of confidentiality
Right.
is by law, this and this and that.
Good.
So they are aware.
So basically, everybody's getting the same ground rules at the same time. It's a good practice. That's the best practice. Yeah, I agree with that. But let's just continue down this road of you've got a bit of a dilemma because your written contract with the people who are paying your bill isn't identical with what you put out there in the note. And as you recall it, you say, you know what, anybody who asked about confidentiality, I told them it was limited by this, but I can't be sure I said it to everybody. So what's the binding contract? I want to know sort of, it's a tough choice. What do you have to operate based on? Do you operate based on the retainer agreement with the employer, or do you operate based on the understanding with the individual employee? What would you say?
I don't think there's any one particular way. I think it's based on a combination of all of those factors.
Okay.
Including the mediator's own values. You have to meet the employer's requirements. You have to maintain the confidentiality of the clients. You have to know whether or not you're comfortable taking a step up going forward beyond the sort of point.
Right.
So it's a combination of all of those factors, not just one. And each mediator may take a different approach on how far they may want to go.
Mm-hmm.
If they want to continue, if they want to step back.
Okay.
It just depends on how comfortable you are in your understanding of the different factors.
Okay. So you'd say it's amalgam of considerations, not just the two contracts, if you will, that you have. Okay. Yep.
I think it's relevant because to me, it is up to the parties, the people who are the claim that they're discriminated against.
Right.
They will decide. Maybe they're not, they're just, no, I don't want to do anything about that.
Mm-hmm.
Then it's a moot point. And, or will they want it, maybe they will approach the employee themselves.
Mm-hmm.
It's going to be them who will decide on the course of action.
Right. So you'd say ultimately that self-determination around how their information gets used is the trump card, if you will.
What about during the conversation with them, they disclose to you that they think they may be being discriminated against. They're not quite sure what the policy would say, and they don't even know where to find the policy. And is this something I should be worried about? You know, and you ask them, well, who would you go to? And they don't seem empowered in order to make that choice around whether they complain or not.
I would discuss with them all the options that they have.
Okay. Would you do anything vis-a-vis the employer, given what you've learned about how well the policy is known and how much education has or has not been done? Would you be doing anything like that around immediately, or would you wait for your report to note those things?
That could be done, I would say, because it doesn't.
Breach confidentiality?
Yeah.
Okay.
Yeah.
So would you do it in the middle of what you were doing, or would you wait to include that as part of your report and recommendations? Okay, okay. There's a back here.
Yeah, you said that, you're retained by the employer, so fundamentally your loyalty is to the employer. However, you're retained on the basis of your expertise.
Yes.
I'd be inclined to think the assessor would do a checklist that could be, and have a generic approach in a public forum with the employees.
Mm-hmm.
And have them honestly tick off things that they feel are pertinent, that may have happened, and then use that as a platform in which to bring up discussion with the employer.
Right.
And I think that would be a catalyst to moving forward in order to go from general to specific
Right.
in trying to come to some agreement with resolving the situation.
So it's sort of a part of what the other person said, which is have a way that you do it in general, part of your system, that you cover off that stuff so that you don't have this kind of a dilemma. I just want to pick up on one thing that was said. Ponder, like, who's the client? Because conventionally we think of the people who pay the bill as the client. But I would argue that when you go in on a workplace assessment, all of the people that you deal with are your clients, including the person who pays your bill. And sometimes their interests are not identical. And that can create some of these ethical challenges. So I know there's more to say, but I want to move to the next thing so that you can have some fun with the next piece.
Can I actually just a couple of practice considerations? One of the things that we do whenever we go into a workplace assessment is have clarity with respect to the limits of confidentiality. And I want to just share with you with a client who the organization came and they wanted a workplace assessment done because they'd heard concerns around not only sexual harassment but personal harassment, and yet they had no complainants who wanted to step forward and make a formal complaint. So they wanted to try to surface these issues. And knowing that these were the types of things that they were actually looking for, hoping not they didn't exist, but looking for, they were very clear in the communication that they sent out to the employees and in the introduction that I did in the interviews what the exceptions to confidentiality would be. So for example, information will be aggregated in order to identify common themes. That's the general. It'll be disclosed in the form of a report to and named the person. With the exception of the two circumstances set out below, any information included in the report will not be attributed to a specific individual. Please be advised that there are exceptions to complete confidentiality. Should the information disclosed suggest that there is an actual or potential threat to human life or safety, that sort of general one, and or a legal or other obligation on the part of the employer to take specific action, such as where there is an allegation of harassment or discrimination in the workplace, it may be necessary for the participant to be contacted specifically regarding the risks, obligations identified above, and the steps that the organization may be required to take to mitigate the risk or fulfill their obligations. So what that's telling the people who are engaging in the process is what can be done with their information. And it's very clear from the onset that if they choose to disclose something that would constitute a breach of a policy, that they may be required to engage in a further process. So that's very clear from the beginning what the limits are. The other thing that I just wanted to raise was, because you'll have these types of disclosures, we'll often take in the policy with us, or the resources in terms of the phone number for employee assistance program, because you can imagine in many assessments the types of conversations that you have. Now that clause, I think, generated a question.
I just had a question. I don't do workplace investigations, but I'm curious. What you said made perfect sense to me in terms of being upfront about what the limits are. I'm curious, in actual practice, does that ever shut somebody down? Like that because they don't want to take it further, that they will not come forth with
It probably does. We don't always know, of course, if they don't. I guess the thing is it's informed consent, right? So if they choose not to, they're big boys and girls, and there's an upside to not coming forward and there's a downside. And we respect the fact that it's their call and it's their information. But you're right, there's a cost to doing that, right? So what I want to do now is I'm going to take you to the next stage, and we make the forced choice at this point. We say, this is what you decided, and now's the situation. And if you're one of those folks who goes, well, I'd never decide that. Well, that's good, but if you want to learn the most from the situation, put yourself in the spot of the dum-dum who did decide that and see what you do from there. Because you'll have more fun and you'll learn more that way, okay? So, you want to read that one?
You decide that your retainer contract allows you sufficient wiggle room to disclose the identity of the employees because the confidentiality provision in your engagement letter contains an exemption for information suggesting harm to the physical, emotional, or psychological well-being of any employee or customer. You cannot be sure whether you explain this exception to every one of the interviewees, but to those who express concerns about confidentiality, you think you did so. Based on the information provided to the client, including the names of the parties involved, and your recommendation for mediation, they decide on a management-initiated fact-finding and perhaps investigation as the first step. As you remember, fact-finding is a less formal and initial determination of whether there's a case that, if true, would substantiate a breach of a policy and would then warrant a formal investigation. There's no point in spending money until we know if there's a real problem and a real liability on the part of the company. Your client wants you to conduct the fact-finding and investigation. You have the experience, and your firm is the client's go-to conflict management company. She would prefer not to take this to someone she's unfamiliar with. So the questions are, can you investigate the concern? Do you have any qualms about the course of action the employer has decided on? Do you conduct the fact-finding and the investigation, given that this goes against your recommendation of mediation? And what else might you recommend, given the client's desire to find out if there was a real problem, a liability on their part?
So we'll hand this out so that you have it. Same deal. You have a chance to chat among yourselves, and then we'll all come together and reason together. Yeah, okay, yeah, that's a good idea. Okay, folks, let's talk about it. By the way, I'm mindful of the fact that when I'm in your spot, I bloody well hate it when the facilitators break in and I'm having a good conversation, so I apologize. Like, I get that. We're just trying to get you through the whole thing. So the one thing I wanted to mention, because I'm not sure I emphasized it when I read it, but what the employer wants to do is they decide on a management-initiated fact-finding and maybe an investigation depending on what the fact-finding tells them. The significance of that is this. They are not requiring those two people to come forward as complainants. So they won't have carriage of the complaint. It's a management-initiated investigation. Now, the implication of that depends on their point of view, but the implication of that from management's point of view is that they'll give evidence to the respondents about the behaviors that were the problem. They won't necessarily identify the complainants by name unless it's necessary for the respondent to make full answer. Okay, so that's a practice question of, is it necessary to identify the individuals by name? And I can tell you there have been management-initiated investigations where sometimes they don't, sometimes they do, okay? Anyway, I just wanted you to understand that so that it's not like the complainants are forced to come forward and bring a complaint they didn't want. However, they are forced to become part of a process that they didn't choose, like they'd be interviewed as prime witnesses, right? And as Heather points out, probably the respondent or respondents would probably see them as adversaries, notwithstanding they did not choose to initiate the process. So, the first question is, can you investigate this concern? What do you think and why do you think it? Anybody? Can you investigate it? Yes?
I call in sick from...
I think you just ducked my question. Okay, others? Yes?
My immediate response is I would have some difficulty because they're not taking my recommendation. On the other hand, I think I probably would be willing to investigate it. However, I wouldn't want to be in a scenario where we've gone through an assessment, we then go through a fact-finding, and then potentially we go through a formal investigation. I think that the employer's getting 3 kicks at the can to make this problem disappear. So I think I would be pretty clear about the criteria of what the investigation would be like and how I would be willing to do it.
So is the concern about doing the investigation primarily about them not following the process you think is most constructive?
No.
Oh, okay. So what is it primarily about the objection?
It's the concern that I have is that it looks as if the employer is trying to have another kick at the can to see whether there's a real problem or not.
Okay.
I will have told them there's a problem.
Yes.
And the fact that they're not listening to that would cause me a bit of worry.
Okay, so your concern is that it may not be or may not be seen to be a fair process because they're trying to skin the cat 2 different ways. Is that a fair summary?
Potentially 3 different ways if
Right.
you go through the assessment, informed, formal.
Yeah, okay, good. Yes.
I think from my perspective, there'd be concerns about having approached the respondents with a confidentiality understanding initially and then going back and re-interviewing them without the confidentiality.
Yeah, that raises another issue.
Like C.Arb, and there's
Yep.
some ambiguity
Yep.
about both those functions.
Yeah, so that raises another issue that I didn't identify here, which is, so if you've already interviewed the respondents, is the information you already obtained from the respondents part of the evidence now, or is it not part of the evidence now? Right? And so people can see the challenge around that. Others? Yes?
I think we're all getting to the same point, but from the rights of the respondent, due process-wise, once you go from a mediation setting to an investigation setting where at the end there could be discipline, including up to termination, and you've led them along that path that ended their job, that exposes the employer and you to incredible liability with lawsuits
So what is that, so how would you answer the question? Can you investigate the concern? What would you say?
Personally, I would not.
You choose not to, for the reasons you've just said.
Because they are different processes with
Okay.
different rights and
Okay.
obligations.
Okay. So your reason isn't primarily around them not following your recommendation, it's morally around procedural fairness, just as this gentleman mentioned. Yep. Others? Anybody with a different point of view on that? So mostly we would, if we did it, we'd do it, and we'd set up a set of understandings around what happens going forward that provides procedural safeguards, or we'd choose not to do it. Is that yes? What most people are, yes, go ahead.
I think it's more or less impossible to do it,
Okay, can you tell us why?
because you've got yourself into the difficult situation of having promised confidentiality and then having to go back and sort of renege on that promise. And then you've kind of been retained by the employer to do a fact-finding, and then you're turning yourself into sort of a quasi-investigator. So you're taking evidence too many different ways. I think you have to step back.
So let me just play with that one for a minute and play the devil's advocate. So what if you simply say either you haven't spoken to the respondents at all yet, which you may not have in the assessment, or you've spoken to them, but if you're like me, you've totally forgotten what they said because you interviewed 7 people that day. But anyway, you're not going to treat whatever they told you as evidence at all because they didn't tell you it in the context of an investigation. But you're thinking, if I start a clean process and I'm doing it as I would if I was retained purely as an investigator, and I don't look at any notes from before, can I do it or can I not? What are people thinking about that? No. So the perception of the employees,
You've met before.
okay?
And what if one of those employees don't want to meet you in the second time? Then
Right.
Do you take the whatever they told you in the first place?
Okay.
And can you carry that over then?
No, not on my scenario, you couldn't. They wouldn't adduce any evidence. But of course, that could go against their interests too, because I might draw an adverse inference from the fact they wouldn't answer the complaint, right?
But the perception is so important.
The what?
The perception of those employees is so important because even if you
Yep.
don't do it,
Yes.
they'll always perceive that you did it.
Okay, yeah, they might.
I want to build on that, and I'm
Yep.
looking at this objectively as I'm sitting on a mountain in Tibet conferencing. But I think the most important thing to me is what you actually underline here. You cannot be sure whether you explain this exemption to everyone in the interviews. I mean, I think that's the fatal flaw.
Right.
You can't proceed with this.
Yeah, so you see that as a big stop sign right there. Yeah, okay, fair enough.
How about the fact that during the assessment interviews, one of the conclusions you reached was that while the discrimination may have occurred, it appeared to be innocent. How might that impact your ability then to engage in that preliminary fact-finding to see whether or not there's sufficient evidence to go forward with a formal investigation?
I still wouldn't, but with that thought, I would want to try and explore with the employer other ways to work around. You know, do they have someone in HR that these people would feel comfortable working with? Or the suggestion that was made earlier about some sort of either a training session or, communication about the importance of, et cetera.
Right, because despite the process, what you've identified in those initial interviews is that there is an issue that exists, an allegation of an issue at least. And depending upon, you don't want to walk away from it, and in what way can the employer be responsive to that and meet their obligations without a huge time lag? Where, let's say, whatever form of harassment or discrimination it is, someone might still be continuing while you're deciding on the next process, continuing to be experiencing that in their workplace.
I think it does come down to valuing the integrity of the process. Because if you cannot be sure that you told the same confidentiality exemption to every single individual, and you're potentially breaking confidentiality, then what does that do to the rapport that you have with those individuals, to the trust and the confidence that they have in the process? And the other side of that is if you've made a recommendation that has not been taken, you have to reality check yourself in regards to biases. So when you look at the integrity of the process, I think you have to look at both confidentiality and your potential biases before you can potentially consider moving forward. And it does talk about, the trust that this company has with your firm. Maybe you recommend somebody else within your firm to
Okay.
take on this case. Or maybe, if you were to move forward, you would have to
So I want to carry that a bit forward. So assume that you decide, for a variety of good reasons you guys have identified, that I'm not the right person to do the investigation or the fact-finding. Is there something you can recommend that would protect the integrity of the workplace assessment process as well as the fact-finding and investigation?
I would, in many policies, it allows for putting the investigation on hold if there's an opportunity for mediation even during the investigation.
Yes.
I would make myself available to carry on the mediation.
Okay.
If the investigator, someone else whom I refer them to or they identify
Right.
seen as impartial,
Right.
if they start the investigation and at some stage the parties that agree to start a mediation, I would make myself available, and that would be in line with my recommendation, original recommendation as a mediator.
So you'd make yourself continue to be available as a mediator, however, someone else would have to do and have been suggested over here that you could maybe recommend somebody within your firm.
Yes.
Would that be a problem? Do you see any problem with recommending somebody within your firm, or do people think that's okay? Just
I actually have a problem with the concept of recommending yourself as a mediator for one of these processes.
How come?
Because I think that there is a perception when you're doing an assessment, a workplace assessment like that, that the recommendations that you make at the end of it aren't going to in some way benefit you.
Right.
So I would be very concerned that, in fact, I would not be the mediator in this sort of
Right.
scenario.
Right.
So perceived conflict of interest, self-interest.
Okay, that's good. One of our clients, for example, in their workplace assessment rules, say that an assessor cannot do any follow-on processes to address that very problem.
Yeah.
It's interesting.
Sorry, I just want to clarify, it's not an obligation in your recommendation that you would be the mediator.
Right, you're just recommending the process.
Sometimes the parties themselves
Yep.
they build so much trust with you during
Yep.
the assessment that they insist, and we have cases like that,
Yep.
that the assessor would be the mediator.
Right, and so then the question is the right test acceptability to the parties if there's full disclosure? And you'd say that would be the right test. Comment at the back?
I just want to make a note in terms of in-house investigation, just because in my experience coming from a unionized background, there's almost an inherent distrust for HR and their processes because they're seen as always in support of management. Mind you, I'm sure that there are many of them who are very objective, but the employees are always afraid of retaliation.
Right.
So they generally don't want to speak to HR about any sort of issues that they experience, especially when there's potential for litigation. So if in a case where I'm the mediator, I may tend to err on the side of recommending that someone from the outside begin the process, just because it may give their parents a more, I guess, objectively, because it's someone from the outside.
Yeah, so you didn't recommend an investigation fact-finding, you actually recommended mediation. But if the employer comes back to you and says, well, we want to do this first to know whether there's really a problem, you could then step in and you'd feel like it was part of your mandate to be able to say, well, if you're going to do that, probably the way to do it is bring in a third party and a third party. And some of you would say that shouldn't be me, and other ones would say it could be somebody from my firm. And some people would say that's a conflict of interest and you probably shouldn't do that either. Is that sort of a summary, eh? Okay, good. So I want to move us on to the next, because you guys are having so much fun so far. Let's just, all right, so, and the other thing I wanted you to notice is, notice how interesting it is when you disclose some information that isn't really yours to disclose, because I take your point, most of you, that you then lose control over what happens with it. Just notice that. Like, you disclose it for a good purpose, right? Hand on your heart, I want to help these poor people. But as soon as you let it go, it now becomes an animal or creature outside of your control. So, you feel badly that the company is turning this into a federal case. That's kind of an American expression, but I think you know what I mean. A federal case against your recommendation. And you believe against the wishes of those who brought their concerns forward. So this idea of turning it into a fact-finding investigation in the first place. You feel that by keeping your hand on the tiller, you can still guide the process to a successful outcome. You decide to do the fact-finding and see what comes of that. In the course of your fact-finding, you determine that there is no prima facie case of discrimination. That means not enough evidence that, if believed, would require an answer, but that there is no evidence of intent. Oh, you find that there is, a prima facie case of discrimination, but there's no evidence of intent on the part of the respondents. You provide your informal fact-finding report saying there are grounds for an investigation, but with no evidence of malicious intent, you recommend offering mediation to the parties. You are asked by management to mediate because you'll be able to do so without the need for preliminary interviews and know the situation and have built trust with the parties. Question, can you be the mediator? Next question, what would you say to the client if you declined? What's that? Now the employer says, okay, that's a neat idea now, and mediation's probably a good idea. This will put a lid on this thing. Why don't you do the mediator? You be the mediator. You know so much about it already. Okay. Oh, so anyway, it's okay. We don't have that much more time, but that's fine. We'll get them
Will
for
we
this.
be able to do the 4th?
I think if we do a really short one, we might be able. Let me look at the fourth and see what it is.
He gave us the 10-minute warning. Let's take this one a little faster than
Okay.
2 minutes. Because I think it's fairly obvious to people.
Want to bring them on further now?
Yeah, I don't know why it didn't go.
Okay, folks, we're going to bring you to order early on this one. In part because we thought this one wouldn't be as a harder one to come to consensus on. So let's hear what you have to say. You were taking this one up, right?
Oh. What are your thoughts? What's going to happen, Margot?
Well, I'm coming from, of course, a family context where we do meet-arts all the time.
Right?
I would say if the parties agreed.
So you'd be comfortable if the parties agreed to your engagement as the mediator? Yeah. So having the family mediation background where, you've sat as an arbitrator, and as long as the parties are comfortable and you're acceptable to the parties. Any other thoughts that people have? Jack?
My thought was no, because you've already, can't come to a conclusion, and that's what you tell the employer, I have to regard it as a neutral. But, if everybody knew, everybody had access to the report, and like, go back to the family situation, if someone said, well, we don't really care about, a remedy other than it stopping, so we'll agree to this, either gal, because, okay, I think you probably could get over with that, but just even the employer, say, no, I really can't do this, I'm not a neutral, because I've already expressed my opinion as to a very important conclusion as to whether it was intent.
So whether or not the parties find you acceptable, you need to reflect on your own ability to be impartial given what you've done already on this file.
I want people to keep in mind, though, what you've done so far is just the fact-finding, which means all that means is you haven't decided whether or not it happened. You simply said, based on what they allege has happened, if it's all believed, right, that's a case that could give rise to an investigation And based on what I understand so far, it doesn't seem like there was any intent. So you haven't actually made a binding, you know, like
You haven't
like
made
done
a
a full
finding.
investigation. You've just basically said there's a case there to meet, and now you've got the choice. You either fully investigate it, or another option would be mediate. Just to be clear about where we're at, right?
Any thoughts that people have about your recommendation to mediate based on what information you gathered during the fact finding?
I just had a question around the intent, and maybe it's just my own personal red herring, but with discrimination intent, it can be intentional or unintentional, right? So,
Absolutely right.
Absolutely right.
was that a red herring that you meant then? Okay.
Yeah.
It was a red herring in as much as you as a consultant are suggesting because there's no evidence of intent, it may be one of those cases where an informal process might work. And for those of you who were at the session this morning, when we looked at investigation and ADR, that's one of the indicia that she indicated that, well, that may be a kind of case where an informal process like mediation might be recommended, right?
I would think that impact is more important than intent in this sort of scenario. As you said, it can be intent, non-intentional. I would not be a mediator on this particular one because I think, as the fellow over there said, you have had to make some value judgments along the way, even if you haven't made a final conclusion. And what I would be concerned about is a human rights tribunal or some court of competent jurisdiction reviewing my actions down the road and concluding that it wasn't a fair process for the defendant natural justice.
Mm-hmm. Yeah. Yeah. At the back.
I agree, I would probably go on the informal, maybe investigative route, if that's the case, but I would not do mediation here, because I think, you know, there's too much doubt here, based on intent, non-intent scenario. I think it's the respondent or the alleged respondent could exactly take it to the human rights tribunal, because it's a lot of, based on, you know, there's not enough evidence to support it.
Right. So when we're talking about if it were to go to a formal investigation and the third party had to make a determination based on the evidence, the intent wouldn't really be the test. It would be the impact on the complainants that would be the measure of whether or not it had actually occurred. So when we're talking about looking at mediation as an alternative, what what you are doing in this circumstance is saying as well, they really didn't mean to have that impact. So I think there's some latitude to have some discussion at mediation because there's a learning opportunity here.
Can I just clarify too? I mean, I'm assuming facilitated, not evaluative mediation.
Facilitative mediation, yeah, I think we're talking about. So I just wanted to distinguish though when we're talking about an impact and intent, how the different processes would treat it differently. And that's why I think this mediator has made the decision even to recommend it. Now, is it the right choice? Many of us have said, no, it's not, for a number of other reasons.
So I want to take you, I'm just going to take you through one more part of the scene, just because I'm trying to stir you up really good before you get your coffee. Okay? Our goal is to get you guys really riled up and then send you out to get coffee. So you decide to mediate, and you decide to do it. And at mediation, one of the two situations resolve. You advise management of that. Management feels that because of a tenuous connection between the two cases, there was a common witness. Remember that way back to there was a common witness? It must go through with both investigations, since there may be seen to be a systemic problem. You are asked to complete the formal investigation. As you've been the fact finder, you'd be the natural person to do it. So, the questions we would pose to you: can you continue, and should you? If you do investigate, what information constitutes evidence and what does not? Does the information provided during the assessment constitute evidence? The information shared in joint session at the mediation, is that evidence? The information shared in caucus in mediation, is that evidence? The information disclosed during the fact finding, is that evidence? All of the above? None of the above.
Question.
Yep.
Can I go back to the yellow sheet?
No, you're on the mountain.
Because I would have, one of the benefits of being a member is I would have called the
Yes. I've been known to do that kind of thing too. Usually, though, I'm asking for, headache relief at this point.
Well, I saw Scott there, so I wanted to, get
Yeah, thanks. So, there's not a ton of time to chat among ourselves. Let's just talk together about this situation. Yeah, comment, question?
My head is just screaming the ethics of neutrality. like going back to the core ethics, neutrality. How would you, I think after all of that, how can you ensure the integrity of the process and the fairness of the process when you already have?
But think of the billings you'd have for that month.
Ethics.
Oh, yeah. Usually Heather doesn't let me take up the ethics stuff. This is a real treat for me.
so why the motto is, I don't agree.
Okay. So, what are your thoughts? Now you've got a golden opportunity to put a bow on this thing, finally to put it to bed, right? So, do you undertake the investigation, and if so, why not? If so, why? And if not, why not? And if you did, how would you sort through all the stuff you've heard to figure out what's evidence and what's not? What do you guys think? Yes?
I would never, of course, investigate, and it's none of the above for any investigator who looks at this. None of the information that was found out in these processes should be taken into consideration.
Okay. Would that include the fact finding, which was done to determine whether or not? Okay. Okay. So that they would start clean. So there would be no, okay, good. Yep. Did you have a comment? Yes, please.
I always try not to think in black and white terms, so I
Okay.
always say it depends.
Yes.
I think it's a safer route to go.
Yes.
For instance, if I have, as a mediator, I have a legal background, and I'm versed in the laws around human rights and stuff like that.
Yeah, yeah.
And I have an investigative experience as well.
Yes.
I may feel comfortable doing this. If I'm not a subject matter expert,
Yeah.
I may defer to someone else. So again, for me, it depends on if I'm comfortable that I have the skills
Yeah.
necessary to objectively look at those situations.
Okay. Yeah. And if you had the legal background, one of the things you'd probably be looking at is, can I offer any degree of administrative fairness given what's transpired so far? And just like the average lawyer would probably run screaming away from this situation, right? Because of all the things you guys have pointed out. So you're right. You sometimes you have to look at it and you say, okay, who would have the qualifications to determine what the right... But I would suggest to you as ADR practitioners, one of the things you should know about, if you don't already, is administrative fairness, the rules of natural justice, and those kinds of things, because they'll help guide you through this, whether you're doing investigation, workplace assessment, any of those things, right? Do you want to put the last slide up?
Yeah, there were many considerations that you raised as we went through the scenarios, and we wanted to give you a little bit of the lessons learned or what the morals are. Certainly, you can get into a lot of trouble when you're invited by a client to go from interest-based approaches to rights-based processes without being very clear with respect to what am I providing as a service and what are the limits in terms of what I can do. The other thing is, I mean, while it's not a real scenario, thank goodness we didn't do this, it's not uncommon for clients to ask these types of questions of you if they feel that you're the professional, we're relying upon, you've helped us out, you've waved your magic wand before, we've got a really difficult situation, what can you do for us? So don't be surprised that you get this type of invitation and that you need to go through the it depends kind of discussion with yourself as to whether or not, would I be acceptable depending upon the process? What do I need to put in place to set expectations? Do I think I'm suitable? Many times the interests of the client will come into contradiction with the interests of the individual clients. So the organization's interests around, we've got a problem, we've got to deal with it, with the individuals who you've interviewed initially in the workplace assessment, just being candid and about things that they're experiencing, not necessarily wanting to proceed with a formal complaint, just wanting the problem to go away is what you'll often hear. When you get into the field of workplace assessments, what you'll find is there's there's very little in the way of professional guidance or standards. And so often you're walking through some of these ethical considerations without, a rule book or guidebook to go by. And that's why we like to work in partnership, so that when some of these considerations come up, you call a friend or you talk to someone else about, I'm getting this icky feeling in my stomach. Do you think there are things that I can do to mitigate some of the concerns I have, or do I just need to walk away from this? How can I do so in a way that preserves my reputation and preserves the integrity of the processes that I'm engaged in? Each process comes with an unstated set of expectations, and we need to take that into account. So if a client is asking us for a process, we need to be very clear what we're contracting for. So if my recent client who wants me to do a check-in, and I assume it's a workplace assessment, but that's not what they wanted, we need to be clear right from the very beginning as to what are they expecting of me, what are my constraints in terms of information that I might find, what can I tell the people who I'm interviewing as to what I'm going to do with their information, and do that in a very respectful and considerate way. And just a reminder that, those billings may have been attractive if you took this the whole spectrum with this particular client, and what's more important is your reputation. And how much money you're going to save in litigation. So lots of, hopefully, things for you to think about as you go off and enjoy your coffee, and thank you for your attention and engagement.
Thanks, guys. It was a lot of fun.
Thank you, Rick and Heather, for engaging us in this. Please, folks,